Oh, there it is. Okay. I just wanted to get the agenda up. Okay. Oops.
We're ready.
And now I've lost it. Okay, hold on. I'm going to start the hearing. 1 second.
We're good. Land. Okay.
Sorry, all. I'm just trying to pull the agenda up, and I'm having a hard time with my computer while seeing this up. Okay, here it is. Finally. Okay. Oops. Except now it overshot. Oh my gosh. Sorry. Okay. Stop. Okay. All right. Good morning. The hearing board of the South Coast Air Quality Management District is in session. Today is November 18th, 2020. The time is just after 9:00 a.m. and we are meeting remotely via Zoom, given the current pandemic and the stay-at-home orders in the state of California still in place. We have one change to our calendar for this morning, and that is the hearing board general meeting has been canceled for this month. We'll have our regularly scheduled meeting next month. We also have one matter on the calendar for today, and then later in the afternoon, the chair has a pre-hearing teleconference. The matter for today is OC Waste and Recycling, Frank R. Bowerman Landfill, case number 5710-4 for a short variance. And who is representing OC Waste and Recycling this morning?
Hello, this is Paul Albarian, spelled A-L-B as in boy, A-R-I-A-N as in Nancy, with the Office of County Counsel on behalf of petitioner OC Waste and Recycling.
Thank you. Good morning, Mr. Albarian. And who is representing the executive officer this morning?
Good morning, Brian Tomasovic, Senior Deputy District Counsel for the executive officer and joined by co-counsel.
Hi, good morning, Erica Chavez, Senior Deputy District Counsel, also representing the executive officer.
Good morning, Mr. Tomasovic and Mr. Chavez. We have we have 2 documents that have been filed since our last hearing in the last couple of days. Find it here. The first one was, I apologize, I've now lost it. Oh, here it is. It was just lengthy and I forgot. Okay, the first was a request for amendment to petition for a short variance. And even though that was filed, we're going to mark it. I believe we're up to number 3 for petitioner in this matter. Is that correct, Madam Clerk?
Yes.
Thank you. And we also have received proposed short variance conditions, and we're going to mark those as B as in boy for the respondent district. I also wanted to go through some of those preliminary requests because we need to do that in the beginning of the hearing. The first request is simply to include as part of the official record this request for amendment to petition for a short variance, and now we can do, and we have just marked it as exhibit number 3. The second is not worded, I don't think, correctly. It says the hearing board shall take judicial notice. However, we're not going to take judicial notice. Judicial notice would simply mean that we're taking it all for its truth. Rather, we will incorporate herein all of the evidence and testimony that was presented at the interim variance hearing on this same matter. The
Thank
third,
you.
yes, let's do that. Let me just first ask Mr. Tomasovic, do you have a objection to that?
No objections.
Okay, thank you. The third one is to take judicial notice of evidence and testimony provided in connection with the emergency variance in a separate case. And I'm going to deny that request. I think you have sufficient evidence that you can present here. However, that is a different matter, had a different attorney for the district, and also was not noticed for today. So for all those reasons, I'm not going to incorporate the testimony and evidence from that hearing. But regardless, I know that you have included as your attachments proclamations or declarations of emergency, and certainly you can present witnesses of the fire and how that affects your request for short variance relief today. And you can do that in a more brief manner, perhaps, than at the last hearing, at the other hearing. But for the reasons that it's not the same matter or district council, I'm going to not incorporate all of that into here. That's not to say it's not related, but we're going to hear about that today. Okay, with all of that, remember where we are right now is there was an interim variance that this board granted up until this board could hear the short variance, which is today. And so today we're going to be hearing evidence on the 6 findings for a short variance. And we have those proposed conditions as well. So with that, I'm going to ask anyone who wishes to be heard today. Oh, Senator. Are you muted? You are muted.
And Exhibit 3, preliminary request,
Yes.
you have in here, the hearing board shall take judicial notice. Why should it even be considered as a separate exhibit? It's part of the.
No, the exhibit, I'm sorry, go ahead.
You said you would not consider that as an exhibit. The statement is included in this request.
No, I included, this is exhibit number 3. So the first request was to include as part of the official record, this request, and I'm doing that. We marked it as exhibit 3, and we're going to consider all of the content as if they had amended their petition. And then their second request, which is not worded correctly, again, it's not judicial notice, but rather we're going to incorporate all of the evidence and testimony in this matter that we heard for the interim. And as you know, that's normally our procedure when we go from interim to short or regular. The third is for a different matter. You may recall there was a related matter regarding the fire at the same facility, but it's a different matter. It has different facts, and it was not noticed for today. And we had a different district council who represented the district and was not, and so Mr. Tomasovic was not present at that hearing. So for all those reasons, and also because it's not necessary. We don't need all those facts. We only need the ones that are related. So,
Good.
okay. So I'm going to ask anyone who wishes to be heard today to please put on your camera and take the oath for today. If you could please raise your right hand. And if you don't have a camera, I know there's at least one witness who does not. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? Just indicate.
Yes.
Thank you very much. Okay. With that, I'm going to turn to Mr. Alberian for your opening on short variance relief.
Thank you. My name is Paul Alberian, and I'm here on behalf of Orange County Waste and Recycling with regard to the variance that here before us. Just as a little background, the reason that I tried to include the 57105 matter was just to get away from having to go through the evidence to try to reestablish the fact that the fire existed and all those impacts. But I understand and accept the hearing board's finding on that. So just moving forward to paint a picture, back on the 7th of October, we were before this hearing board and successfully established good cause for an interim variance, as well as we met the 6 findings that are required under the health and safety code. In terms of the 6 findings, really nothing has changed in the sense of whether or not they apply or not. And I think to some degree, we just really can submit on the petition if that's an option. I think one of the main priorities of this hearing is to get the short variance coverage and in a sense explain why we weren't able to do more since October 7th. And so I think really the point here is our plan would be to establish some facts regarding the cause of delay and the impacts of the fire. And then beyond that, submit under the petition unless this hearing board believes that we need to do more.
I believe that is what we need to hear today is what is the situation. I believe we can take judicial notice of the fact that there was this fire. Certainly that we can take judicial notice of and when it was. And if you, as you just mentioned, if you can just update us as to how that fire has impacted the flares that are at issue here and the running of those flares and the compliance under short variance. I also want to hear, having looked at the proposed conditions, I want to be clear for everyone so we know what we're talking about as we hear evidence, but a short variance can only be granted for 90 days, and that includes all interim relief that has already been granted. And this morning, Madam Clerk informed me that that date, I believe, is January 4th. It does not seem to me that under the conditions and what we've heard so far, what I've read so far, that you'll be finished by January 4th. And if that's the case, you'll have to explain that. We'll have to hear about that. And you're going to also have to be noticed and request regular variance relief. So let's talk about that as well. Thank you.
Thank you for that. So with regard to my opening statement, that really is it. I'd like to update the hearing board, and I have some people here on Zoom, not in person, but they are here on Zoom. And I believe that my witnesses today who have already sworn are Robert Peace, who is Orange County Waste and Recycling's Renewable Energy Manager, Jeff Arbor, who is Waste and Recycling's Environmental Services Manager. And Jeff, unfortunately, has some camera problems, but he is online. And Sharon Frank, who is a representative of our energy partner, Montauk Bowerman Power, and she is the director of their environmental health and safety. And if you recall, she did a significant amount of the testimony in the prior hearing. So that really is my opening statement. And I think I probably, once again, going beyond where I'm supposed to, so I can take a break if district would like to respond.
Yes, thank you. And we will go to Mr. Tomasovic or Ms. Chavez. I'm not sure who's going to give the opening statement.
Good morning again, Madam Chair, members of the board. As you've just heard, there are some changed factual circumstances for the facility since the interim variance was previously granted on October 7th. As you'd expect, I have conferred with counsel for the petitioner in advance of the hearing. So what you have marked as Exhibit B is something that was shared with the facility in advance. And my understanding is that they don't have any objections to it. We had also in advance discussed the running of a 90-day clock. So as you look at condition 6 of Exhibit B, one way to read it is, I don't think they would object if you added in no later than January 4th. So no later than 14 days after normal operations are resumed, and no later than January 4th of 2021. On that, there is, as I type into Google what is 90 days from October 7th, it actually comes up with January 5th. So there may be one additional day to work with. But that's just by my informal method. One nuance that I think might be important for the board to understand is the failed source test results that brought us here. My understanding is that it's petitioner's position that these failed source test results show non-compliance with permit conditions as the energy plant is in operation and working in conjunction with the flares, and that they do not necessarily show days of violation or violations of the permit conditions when those flares are operating not in conjunction with the power plant. So as the facility phases in, and I guess you may hear testimony that the flares are online or soon online, however, the power plant is not, those flare days of operation are not necessarily the violations that were covered under the interim variance. So the fire had the consequence of maybe derailing their plans to do proper source testing in conjunction with the power plant being in operation. So that's just something to keep in mind. I don't think it frustrates the board's ability to make the finding that the facility is or will be in non-compliance for some number of days and does need the variance coverage. And I also concur with Mr. Alberian's representation that a lot of the evidence that satisfied the board for an interim variance last time does carry forward. There's just some adjustment of the facts with the circumstances of the fire. And we do have a district witness who would be available to answer questions about Exhibit B if there are any, but I think if you look it over, you'll see that these are largely track with conditions that were set last time. There is the updated fact that the facility has already undertaken the internal cleaning of the flare mechanisms that they had some hope would give them successful source test results. So that was dropped as a condition. I should add, I don't know if the version you're seeing has an asterisk on condition 13 related to fees. We did make some adjustments to the language to say all applicable fees and any applicable excess emission fees, and that's in recognition of the request in the amended petition that that they would be seeking some waiver or reduction in fees. And so to the extent the board, whatever way the board goes on that, the phrasing of applicable fees is meant to be sort of versatile. If there are no applicable fees, then condition 13 is basically a moot condition. So with that, we look forward to hearing petitioners' further evidence today. Thank you.
Thank you, Mr. Tomasovic. Mr. Alberian, as you go through your questions and as you go through testimony with your witnesses, can you please try to separate out, and knowing that most emissions from this landfill are now covered under a separate variance. To the best of your ability, as Mr. Tomasovic was just explaining, but I think it was a little unclear that use of these flares for their usual purpose of gas collection, that's what this variance covers. But use of it for what I believe flare 4 is being used for is something different and covered under the other variants. To the best extent possible, if you can just try to make that very clear, that would be very helpful moving forward.
I'll do my best.
With that, you may introduce your first witness.
Okay, for my first witness, I think I will be calling Sharon Frank. And Sharon, will you just confirm that you took the oath earlier in this call?
May I just, I'm sorry to interrupt, the senator had either a question.
Condition number 13, as you were explaining, applicable fees are excluded from the emission. Is that correct?
I'm sorry.
Item
What was your,
condition number 13 shall pay applicable fees to the clerk. Those fees could be separate from the emission, the fee that is attributed to emission. Is that correct? Yes. Or
Yes.
no? Okay, well, fine. So therefore, those are required under any circumstances. Is that correct?
we're going to go through that. The request is to waive fees. Whether we agree with that, I'm not sure. I'm not sure.
Not according to 13.
Well, 13 petitions shall pay all applicable fees. The asterisk says this is without prejudice to the request today. The request is to waive those fees. We will take that up after. Is that your question?
What I attempted to argue is if the board were to adopt our proposed condition number 13, it wouldn't be a problem if the board were to later make some decision about reducing or waiving fees, because the board would then be deciding that those fees aren't applicable. So I think that the point was we have that condition there. We think it's durable and works under whatever circumstance the board might later decide the fees should be.
So that request is on the table, but we need to deliberate later on that. Does that make sense?
No problem.
Okay, sorry for the interruption, Mr. Alberian, and you were introducing Ms. Frank.
Yes. Ms. Frank, are you on the line?
Yes, I am.
Okay, so bear with me. I'm gonna kind of use you to lay some groundwork. I want to establish a record that the fire happened, and then we can go into some of the impacts. Is it accurate to say that on October 26th, there was a fire called the Silverado Fire that impacted and damaged equipment at the FRB landfill?
Yes.
And as far as you know, and I think they are part of Exhibit 3, are you aware that the County of Orange declared a local emergency in connection with the fire?
Yes, correct.
Okay, so regarding, can you quickly describe for me and I believe that it was already established in the prior hearing, but just as a matter of background, the primary purpose of flares 3 and 4, which are the subject of this variance, what is the primary purpose of those two flares?
The primary purpose of flares 3 and 4 right now is to combust the regeneration gas from the cleanup process, the siloxane cleanup pretreatment process for the electric facility.
Okay. And can those flares operate in that primary capacity when the power plant is not running?
They cannot. They cannot.
And when the flares did not pass the source test before, it was a failure to pass while they were operating in that primary capacity. Is that
That's
correct?
That's correct.
Okay. And I think I already asked this, but did the fire impact the ability of the power plant to operate?
Yes, definitely. It destroyed cables and of course all the inlet gas. I mean, we need the gas from the well field.
Okay, so is it correct to say that the power plant and flares 3 and 4 have not operated in conjunction with each other since the fire, which started on October 26th?
That's correct. Yes, that's correct.
And today, the power plant is not operational. Is that true?
It is still not operational.
Okay. I'd like to go back a little bit and bring you back to our October 7th hearing. In that hearing, we had just learned, basically, we were talking about the fact that we did not pass the source test on those 2 flares. Since that time, what actions have been taken to clean and repair the flares?
Okay, so Bowerman Power called in a contractor to clean the internals of the flares and inspect the insulation, and they completed that work on October 23rd.
Okay. And at that point, was a retest scheduled?
A retest was already scheduled for October 26th and 27th, but of course the fire occurred.
And so we were planning on doing a retest, but the fire occurred, which is a local emergency and damage, etc. So we were not able to do the retest. And okay. And as you said, the power plant and the flares have not had an opportunity. The power plant is not online, therefore that combination of activity is not able to be accomplished. Is that true?
That's correct.
One moment, please. Can you, I know that a lot of work has been going on in many areas to get things back up and running. Are you able to give us an idea of the status of repairs to the that are needed for the energy plant, and what, maybe what has been done and what is still outstanding?
Right. The energy plant, basically the inlet electrical and fiber optic cables were damaged. Okay. And we currently, AT&T actually is on the site right now, repairing, looking at this fiber optic line, which is the very last repair that's necessary for the power plant to operate, so that there can be communications with all of these systems to run the plant.
Okay, so gas lines and mains have been connected sufficient that if those other repairs were done, you have gas flow at this point, hypothetically?
That is my understanding, yes.
Do you have any idea? Well, I'm going to go back a second. It's accurate. I know that Southern California Edison has successfully re-energized the site, and now there's power back generally to the site. Is that true?
Correct. Yeah, that had been accomplished, I want to say the 7th of November.
Okay. Do you have any estimate that you can provide of when you think the power plant might be back online?
Actually, I cannot. We are getting from the site that there's about 4,000 feet of cable that needs to be replaced, this fiber optic cable, which is quite a bit. We're learning right now as we speak on how soon AT&T will be able to really repair this.
Okay, so we just don't know. Is it possible that the repair can be made within a month?
It's possible, but I would not be able to say that for certain.
Okay, we just don't know.
No, that's correct.
Okay. One moment, please. Is it your understanding that is there a backup role that these flare and 3 and 4 are used for?
Yes, sir. They are used to burn landfill gas when the plant is down.
Okay, and I believe that we established it in the prior hearing, but is it possible to, when the power plant is down, are flares 3 and 4 required to be in operation for that backup role, or can you just not use them?
They're required for the amount of gas coming from the landfill. They are required.
Okay. And let me talk about the issue of when the power plant is back online. Are you able to just immediately retest the flares 3 and 4 when it's back online, or what's the process that might be required? Let me back that question up for a second. Before we talk about the retest, what do you have to do to determine whether or not the power plant can be brought back online regarding maybe quality of gas or volume, that kind of thing?
Okay, we do have certain specifications for oxygen content in the gas, and we try to keep the methane quality within a certain range so that it's not too rich or not rich enough. So there appears to be sufficient BTU content to the landfill gas to bring it online right now. And as long as the oxygen levels are low enough, the plant, that's what's necessary. So I believe that work is ongoing to get the well field balanced out, and it shouldn't be a problem.
Okay, and you know that about the quality of the gas, how?
Because that is basically the specifications for the engines. They have to operate on certain quality of gas.
But I to rephrase that question, are you aware right now that if the power plant was completely repaired, all those pieces were repaired, there would currently be sufficient gas quality and volume to go to the power plant, or do you not know because the system has not been tuned?
The landfill does need to be tuned. So when we do start the engine facility, it will be I guess a trial and error period initially to make sure everything is tuned and consistently, the gas is consistently of the correct quality. Okay. The flares can combust various qualities of gas. Okay. Compared to the engine facility, they will need a consistent quality of gas. In addition, we'll need 4 running days. The plant has to run at least 4 days in order to get through the regen on each of the vessels in the process. So that's necessary to break in the regen, the pre-treatment process, before we can really start sending gas to flares 3 and 4.
Okay, so at the very least, once the power plant, is it correct to say that once the power plant is turned back on, that there will be some period of time after it's operating, that we need to wait before we can retest?
That's correct. At least the 4-day period. Yes.
Okay. All right.
I'm sorry, just while you're on that, I just want to clarify. You're saying 4 days are needed to wait to test. Also, 4 days are needed to wait to restart the flares in that capacity?
4 days are needed to restart the flares in that capacity because you have to run it through the vessels before they need regeneration.
Okay, that's what I thought you were saying. I just wanted to be clear. Thank you. Sorry. Go, please continue.
One moment. And give me one moment to just gather my thoughts.
Take your time.
Are you aware right now as how many flares are in the entire flare facility? Are there flares in addition to flares 3 and 4?
Yes, there are 1, 2, 3, 4, and 5. There's 5 flares.
Okay, and are you aware of whether or not the flare facility is currently in operation burning landfill gas, not the power plant, but just in their backup role?
Definitely, yes, they are burning the excess gas. I'm sorry, the gas off of the landfill.
And that is the result of a concerted effort to repair the system from the fire. Is that true?
Correct.
And when, if you know, did landfill gas resume being destroyed through the flare facility? If you know.
I think it was yesterday.
Okay. So either yesterday, which was the 17th, or Monday, which was the 16th. And I can ask some of the other witnesses who may have more. If you don't know, that's fine.
That's right. I'm not certain of the exact date.
But at the very least, you are aware that they are currently operating and burning landfill gas.
Yes, I am. Yes.
Okay. I have nothing further for you at this time. I thank you, and I'll see if District Council does or the hearing board.
Thank you. Mr. Tomasovic, Ms. Chavez, any questions for Ms. Frank?
Yes, Madam Chair. Ms. Frank, the original failed source test results are what brought you all in with the petition for a variance. Is that correct?
Yes, sir. That's correct.
And did those source test results, were they conducted when the power plant was not in operation? Were they conducted when the flares were in just their backup roles?
They were conducted when the plant was running, and that's their primary role.
Okay. Is there a reason to think that the flares are in violation with permit limits performing in a backup role?
Definitely not, because the limits are the same for operating in the backup role on landfill gas as it is for regeneration gas. And that was the condition that the department had left, what was required for the permit for the modification of those flares.
Can you, so you're saying that the permit limits are assigned for when the plant is in operation?
Actually, the initial permit for the modification of flares 3 and 4 had the condition that the flares had to be tested when regeneration gas was sent to the flares. However, the emission limits remained the same as always. So yeah, there was no increase in emissions. So in other words, the emission limits are the same for regeneration gas as it is for landfill gas.
So wouldn't that mean that the flares are in violation in whatever capacity they operate until you have a successful source test?
You can assume that, but it was not tested on landfill gas, but that could be an assumption because the emission limits are the same.
Okay, then potentially you would be seeking variance coverage for those flares in all capacities of operation until you have a passing source test result? Or are you only seeking variance coverage for when the power plant is operating?
I believe we're seeking coverage for the flares operating in all scenarios.
Okay. About the 4,000 feet of fiber optic cable, could you explain exactly how that relates to resuming power plant operations, or?
Yes, the fiber optics cable is what is necessary for all of the communications equipment to talk to each other in order for the plant to operate. I mean, you will need, all of the transmitters from the equipment itself to be tied into the plant system that controls the SCADA system that controls the operation of the facility. So that fiber optic cable is needed for that.
Do you know whether that's multiple lines or a single line that's otherwise buried or hanging overhead?
Yeah, my understanding, I don't know if it's buried or not, but I think it's maybe just one cable. I can't say for certain exactly the configuration of that cable. It's one cable above ground is the information I'm receiving.
Have you had a chance to look at what was marked as Exhibit B, the proposed short variance conditions?
For this variance?
Yes.
Yes, I have.
I don't know if you have that in front of you, but condition 6 is written to say petitioner shall conduct a retest for PM ... to demonstrate compliance no later than 14 days after normal operations are resumed. And then they give the facility ID for the power plant part of it. Do you think it is feasible for the facility to conduct a retest in the month of December?
I cannot answer that question, honestly. I cannot. I do not know the scope of the AT&T actual work or their ability to complete it, their time frame for completion.
Do you think you would be able to answer that within a week? What are you waiting for in terms of information from AT&T?
They initially told us that this cable had to be ordered and that it was going to take a couple of weeks to receive it. That was the initial information. So unless they're telling us something different today, they are currently on site, as I indicated. Our understanding, so if this is the 18th, we're talking the beginning of December for them to even get it in stock.
Okay. And again, with reference to Exhibit B, I don't know if you can see proposed condition number 7. Sorry, condition number 8, which had stated the facility would submit source test results no later than 7 days following the source test. So I guess my question is, would that put the facility even in a greater crunch if that condition were interpreted to mean the source test would have to be not just by January 5th, or January 4th, but 7 days earlier in order for you to meet that condition of submitting the source test results? Does that make sense?
Yes, it does. I mean, I understand if we were to have the results prior to the January 5th date, that 7 days would have to be factored in.
Okay. I have no further questions.
Okay, we're going to take board member questions, but first I just want to say, before we forget to say this, it takes about 45 days from petitioning to a hearing date for regular variance. It has become very clear, I think, so far that through no fault of petitioner, you don't know if you're going to fall within the short variance time frame. So I just want to make sure that we're very clear that you will need to apply or petition for a regular variance soon, so that you can be heard should you not meet that timeframe. Just wanted to make sure that was clear. Ms. Frank, I had just a few questions. Were either flares 3 or 4 damaged in any way by the fire?
That is my understanding, they were not.
Okay. I was confused by the amended petition statements as to whether flares 3 and 4 are currently being used in their backup mode. It said 4 was, I don't know if 3 is, and is 4. Which are they being used?
Currently, what we are operating is flares 2, 4, and 5 to combust the landfill gas. Flare 3, they're experiencing a harmonics problem during startup, possibly because of the amount of gas that built up in the landfill, and we're not certain. It may have been some damage to one of the flow meter calibration, the calibration or some instrumentation that we're getting checked on flare 3.
And why not 1?
That's the oldest flare and typically is the last to be started up.
Okay. How often on just under regular operations are 3 and 4 operated as backup flares in their backup capacity?
They have not been. It has been a very, I can't even say the percentage of time that the entire plant has been down is just so minimal that I don't think that they've operated on landfill gas. I don't think all year.
So in your opinion, the use right now of flare 4 and the possible use under a variance of flare 3, that is really, in your mind, is that a direct result of the amount of damage that was sustained to the landfill as a whole in the fire?
Not really. I mean, flares 3 and 4 are fully capable of combusting landfill gas at any time. It's that they haven't been needed for the duration of the downtime for the engine facility.
Okay, but under regular operating circumstances, it would be very unlikely that 3 or 4 would be used. Was that your?
That's correct. That's correct.
Okay. Okay, those are my only questions. Board members, Mr. Balagopalan.
Yes, Ms. Frank, are you handling also the environmental at Bowerman power plant, or is that handled separately?
No, that's my responsibility.
This is the first time we're seeing a different ID for the power plant versus the landfill. Are they 2 different entities, ownership, or?
Yes, that definitely, they are 2 different entities.
But you're handling both the landfill and the power plant?
Actually, not to a certain extent, we are contractually bound to Orange County Waste Recycling to conduct their NSPS monitoring for the landfill, as well as to operate the flares under environmental regulatory requirements.
Okay. So they have their own Title V permit, or if they need one, or?
Correct.
Okay. So when it says in the order in Exhibit B that within 24 hours of the plant resuming operation, what does that mean? There are, I think we saw in the petition there are 7 engines there. What is considered resuming? Did all 7 have to be in operation, or?
Typical operation of the engine facility is all 7 engines operating to generate. It's a gross of 20 megawatts that we put on the grid, so that would be normal operation.
But to do the testing for flare and 3, if they're back in operation and the repairs are done, will all 7 have to be also in operation, or you can do it on with
It doesn't matter the number of engines, yeah, because all of the gas going to whatever engines are operating has to be cleaned up in the pre-treatment.
Just following on that, should we then be adding the word normal operation? Are we talking about condition 5?
Yes, that's what I was, trying to qualify what operation means. Is it all 7, or is it, what the condition?
Yeah, normal operation would
be a correct word. And Mr. Alberian and Mr. Tomasovic, do you agree to adding the word normal?
No objection.
Mr. Frank,
No
now
objection.
Oh, sorry.
Go ahead. I'm sorry. I didn't mean to interrupt. I just wanted to get that sealed. Thank you.
No. Since the source test date has been rescheduled, is the source testing company on standby? Because now it's a floating date. Are they available on your call to come? How soon can they come to your facility to do the test?
We are running out of good standing with our source testing company. Yeah, we are just trying to obtain their availability when we can. We have a couple of available dates from them right now, but they would not be able to just turn around and come like tomorrow, or if we were to request them to do that. Very likely they're scheduled someplace else.
So that's okay. So
Yes.
that's also not known, because even if you're ready, if you're not sure, they can come and do it before January 4th, potentially.
They work with us. They have worked with us for years, so it's feasible that we can request, I would say, at least a week of some type of, change in schedule with them. So maybe 7 to 10 days, we would be able to get them to work something out to come and test for us.
Okay. In your past experience with the testing company, I'm just wondering how, there's a requirement in a read condition number 8 that you submit the source test for expedited review. How fast can they turn around the source test report for review?
Actually, 7 days. We have never seen a report turned around in 7 days. But what we would do is to expedite the laboratory sample results, and we would have the results within 7 days. That is how we actually interpret that requirement.
But you may not get the report within 7 days.
That's correct.
Yeah, okay. Because it's a fast turnaround in 7 days for a company to write up the whole report and get all the analysis done. Am I correct?
That's correct, sir. We would just be providing results, the particulate results within those 7 days.
So then condition number 8 says the submittal of the source test report of the retest should be no later than 7 days. Is that going to be a problem?
Again, well, if it can be interpreted that the submittal of the source test results is not the formal report, but just the results of the PM test itself informally, then that should not be a problem. But if we need the formal report, we would need, yes, at least I would have to give them, well, since it's only PM, maybe 10 days, 14 days. I cannot exactly speak on their time they needed to prepare a final report, but it is only one pollutant, so.
We will need to clean that up and be more clear as to what would come within 7 calendar days, or to increase that amount of time. So,
or if it's even possible, maybe we need to find out from district staff what they will accept as a sources report, whether they will accept preliminary data or they need the full report, which in that case, it may have to give more days for them to submit that report, I would believe. And
we can have the parties take care of that. Thank you for raising
okay.
it. let's have.
Okay, that's all I had. Thank you, Ms. Frank.
Okay, board members, any other questions for Ms. Frank? Before I move, Senator, yes, and you are muted.
These proposed conditions were prepared by the district in combination with the respondent. The district prepared these conditions. Well, the district should be answering why they put it.
Yes, Mr. Tomasovic said in his opening that, oh, go ahead, Mr. Tomasovic.
We prepared it, the conditions in Exhibit B, yes. We shared them in advance with the petitioner, but
You prepared it in such a manner. I mean, we're asking about conditions, not you should be the one answering.
No, what we need to do is we need to gather evidence from the proper witnesses so that we can make sure that each condition is supported.
And what we should do is ask the witness, are they familiar with these proposed conditions? Yes or no, and if they are, then what do you see that should be changed in these conditions? That would agree with your understanding what the operation is about.
Correct, and that was what Mr. Balagopalan was doing. Did you have additional questions with regard to the proposed conditions?
No, I just thought to simplify it, let the Ms. Frank answer. Are you familiar with these proposed conditions, Ms. Frank?
Yes, sir.
Any part of these conditions that you take issue with?
Well, as we just discussed, maybe clarification on the what will be acceptable by the district as far as source test results.
Well, you should go. I would suggest you go down each one, unless you can identify one condition that you have concerns about, and you can eliminate a lot of the cross-examination.
That's really the only one, sir. The rest of these we have been complying with already.
That's your answer to everyone concerned.
Okay, well.
if I may, I can represent that these questions on condition 8 source test results was meant to refer to preliminary source test results. So we did have that in consideration. And I can proffer that if I call the witness, the same thing would be said.
Okay, so what you're suggesting is we would change that to say petitioner shall expedite to the maximum extent feasible the submittal of the preliminary source test results?
The phrasing source test results was meant to encompass preliminary results. It wasn't an expectation that the full report would be available within 7 days, or the formal submission of the report.
Okay, so at this time, you don't want to make a change to that, or we'll just base it on the understanding today at the hearing between the parties? We definitely don't want to set them up for failing to comply with the condition.
Right. Yeah, unfortunately now as I look at all of condition 8, including the 301V reference, I may need to check and say that there's not a disconnect. I do recall that I had a conversation about what would be available within 7 days shouldn't be expected to be the full report, but I'm not sure that that matches up with the corresponding expedited review request under Rule 301. So by the time of closing statements, hopefully I can give you a correction on that if one's needed.
We can do that. We'll definitely be taking that a break before that. Any other questions though, before we move to?
To address the senator's the comments in general, yes, number 5, I think we went over that perhaps that could be clarified to say resuming normal operation.
Right, and there was agreement amongst both parties, no objection to that. So should we grant the short variance and these conditions, we will make that change at that time. Okay, any other questions for Ms. Frank before we move forward? Okay, thank you, Ms. Frank. Mr. Alberian, you are next witness, please. Oh, you are muted.
I have no further witnesses at this time. However, am more than happy to make available the representatives from Waste and Recycling if you have questions that you feel have not been answered.
Anyone have any questions that they need answered before making any of the 6 findings? Mr. Balagopalan.
Thank you, Madam Chair. I know at the last hearing, we had some questions about the rules that may apply. And at that time, the source test report, which indicated non-compliance, was preliminary and didn't have data, specifically on rule 404, 409, if the test indicated violation of those rules. I was just wondering if subsequent to that, since the interim, whether staff had an opportunity to look at that test and see if it still needed relief from those 2 rules.
I think that I will ask our representative, Robert Pease, Pease, to answer, and he can advise me if I'm selecting the wrong person.
You may be selecting the wrong person, Paul.
Do you believe that that question can be answered? Who would you recommend I have called? Is that Sharon or Jeff?
Yeah, possibly. I have not personally made that calculation based on the source test.
Sharon, do you have a different answer than that?
I'm sorry, could you repeat the question, please?
Would you like me to? Or?
Yes, sir.
Please.
Yes.
I'm sorry.
Oh, yeah, Ms. Breno, at the interim hearing, there was, I think, the sources data that was received by the Orange County district was preliminary, and there wasn't sufficient detail to make a determination if there was also a violation of Rule 404, 409. I'm just wondering subsequently if you got a more comprehensive report that indicate that those 2 rules were also violated.
No, we have not. The source test company did not provide a more comprehensive test as we were preparing to retest.
Okay, so then you would, for abundance of caution, you would need relief from those 2 rules then also.
Right. That's
Yes,
right.
please. Yes.
Okay.
And the interim did include that, so we will.
Yes, it did. Yeah.
The motion would be to continue that.
Right. That's all I had. I just want a clarification.
Thank you for that. Any other questions that board members you believe you need answered before we can make the 6 findings for a variance? Okay, thank you then. Mr. Tomasovic, you indicated you have no additional witnesses, correct, that you wish to put on?
Madam Chair, if I could call a witness to tidy up proposed condition 8, I think that would be good. I just have a question about that.
Okay, thank you.
So respondent calls Miss Nicole Idiart.
Hello.
Hey, good morning. Could you please state and spell your name for the record?
Yes, it's Nicole, Nicole, Idiart, Idiart.
And did you take the oath this morning?
I did.
And what is your position with the AQMD?
I'm an engineer, air quality engineer.
And did you help in the development of what's been marked as Exhibit B?
Yes.
Do you have that in front of you?
Yes.
Okay, so my question is with condition 8, it said the submittal of source test results
Yes.
within 7 days. What was intended in that phrase of source test results?
Our intention was that we would need the full report. We would need to have not only the preliminary results, but also means to verify that the testing was done correctly, the methods, and et cetera.
Okay, so I was mistaken or misunderstanding. I guess I have no further questions with that.
Okay, so then what we'll need to do then is reflect. I think that we'll have to take a break at some point and have the parties discuss what is the appropriate amount of time for that, unless we can decide that now. Well, first, let me ask before we do that. Mr. Alberian, do you have any questions on that for Ms. Ediart?
I do not. I mean, Ms. Ediart testified to the intent. I do agree and appreciate the courtesy of this body and all the people involved that we put something in there that is reasonable and that we can comply with. So if that needs to be changed, I do appreciate the courtesy of everyone involved to assist making that happen.
Okay.
I will explain. My understanding of that condition is it is a marker, so to speak, of us and a requirement for us to take in information, but ultimately the submission of the source test results is not a verification that the facilities come into compliance. There may be a subsequent review of those source test results to make sure that all the bells and whistles of the protocol were followed. So it is a bit of a case of going in blind, so to speak. The fact that the source test is conducted, everyone's fingers are crossed that those source results will ultimately prove successful. But it might be 3 months, 4 months later where a review of those source test results might actually come back to say the facility still has some problem. And so some sort of enforcement action or variance coverage or order for abatement may be needed for the facility. So I think the best that can be hoped for, which I think is consistent with variances that have been granted for facilities with failing source tests, is that they are in a position to try to get a source test conducted and have that hopefully be successful, and hopefully it never has to come back to the board. And so in a sense, condition 8, I think it would have to be if it is included, it is a condition that would have to be met logically within the 90-day period of a variance. But I also think it's a little bit extraneous in terms of the submission of those, the act of submitting the results actually doing something to show that the facility is in compliance.
Well,
sorry, that's complicated, but.
Let me ask Ms. Ediart, do you know how long generally on average it takes to receive source test results from a facility?
I don't know.
Okay. Do you know if, I believe, and we can go back to Ms. Frank, but I believe Ms. Frank had said 14 days would be a reasonable amount of time. Does that seem reasonable to you?
Yes, Madam Chair, that's actually what we are getting from our contractor right now. A full report within 2 weeks.
And Ms. Ediart, does that seem reasonable to you?
I wouldn't know specifically, but I would believe that, yes.
Okay. I just had one other question for you. I don't know if you know the answer to this, but are you familiar with these flares 3 and 4? And do you know, and specifically, do you know whether their use as backup flares is a violation because the source test showed PM to be excessive, as opposed to their primary use? The question is, right now they were source tested and they're in their primary use. They did not they were not successful. They failed for PM. They're now, or at least one of them is currently being used as a backup flare for landfill gas. Since the source test was not successful, is use in your mind, do you know whether, can you make a determination? And if you can, is that use for just burning as a backup landfill gas, is that a violation because they didn't pass the source test?
I wouldn't be able to say what the emission rates might be during, now that they're using landfill gas, since the test was specifically for its other purpose with regen gas.
Okay, so you don't know if it actually applies, the source test, because they're done under a different set of circumstances as the primary purpose of the flares, or the, what is it, the energy?
But its primary purpose, yeah, is the use of the regen gas, would be my understanding, which was what was occurring at the time of the testing. But now that they're using landfill gas, I don't know that I could say absolutely that those emissions necessarily apply.
Okay, so
maybe Sharon would know. I'm not sure.
is there someone else? What I want to understand before we end this hearing and deliberate is the scope of what we're talking about. Is the variance including use of the flares for their backup purpose, and does it need to? So I guess if someone from the district might be able to answer whether this would be enforced or enforceable because they're using it as a backup, but did not pass the source test under the primary conditions, and whether we're including that as part of the variance. Is that understandable? So
yes.
Can you answer that, Ms. Ediard? And if not, Mr. Tomasovic, do you have someone who might be able to?
My understanding would be that I would assume, like, for instance, if I was to calculate the emissions occurring at this time, that I would just apply those emission factors from the last data point that we have moving forward to apply for the combustion of landfill gas also, if that's what the question is.
Okay, and then you would have to see if the source test. Okay, no, I'm not clear. So if the source test, they fail the source test, clearly if they're using it for the primary purpose of the regen, that's what they need the variance for. Do they need the variance for use of flares 3 and 4 for backup purposes?
That I'm not sure if that's, maybe Mr. Tomasovic.
Yeah, I regret coming into this hearing under a misimpression that the facility might well be okay when the power plant's not operating. I had thought I thought that was the facility's position coming in, and I thought there might be some explanation in terms of when the power plant is running, perhaps there's additional siloxanes that would lead higher PM results. And so I can't say that the district does have an enforcement position, or that it's been discussed with enforcement, and that Ms. Idiart represents the permitting division of AQMD. So based on the testimony heard today, it is different from what I had said in my opening statement and thought to be the case. And I think there is some argument that failed source test results for the facility in one mode of operation, that is with the power plant, could be indicative of the flares also failing to meet the PM limits that apply in their backup role. So it's understandable that they would want that coverage. It's just my mistake for thinking that that request for coverage didn't apply. So I guess if the flares were in fact restarted yesterday, then there is an argument that they would seek and want to have variance coverage starting from yesterday. It is still the case that as the facility had shut down because of the fire on the 26th, that all those days where the facility was fully out of operation with its flares, you don't have days of violation or any excess emissions that really pertain to the interim variance. It only applies when the flares are fired up.
So if I may interject here, two things. I do believe that based on this conversation, we would want coverage under the backup operation. However, I'm wondering if the 5701-5, which is a much more global and broad variance, because that is directly related to the fire, and it does cover the landfill gas flaring system. So I think, unless I'm mistaken, and I didn't dive into it, but unless I'm mistaken, we are okay to kind of focus the way we're focusing right now on the -4 case, because the -5 case really covers the operation of the flare, all the flares and the whole LFG system as a result of the fire. So,
and that was my next question. So that makes sense. But what I'd like to do is I would like to take a break. And in the break, I want to, Mr. Alberian, if you could verify that you believe that use of the backup flare, use of the flares as backup is encompassed in that broader variance, and don't wish to have it be under this variance as well. Please make sure of that and come back on that. And then Mr. Tomasovic, if you wish to, if there's any other changes to the conditions that you wish to make, let's take the time to do that, and we'll come back for closing. Senator, I think you're muted.
You're muted, Senator.
Mr. Albera is making a statement, and then I don't know if he finished his statement, then you start to make comments while he was making a statement. My question, did he finish his comments? You did? Okay, very good.
Yeah, it was where we were going, which is the use of the flares as a backup may already be covered under the other variants. So to shortcut that, I want to take a break and allow Mr. Alberian and his team to make sure they feel comfortable with that, and then let us know what they're requesting today, so that we know the full scope of what we're going to be deliberating on. Okay, so why don't we take a 20-minute break, so that that will give you plenty of time to do that, and anything Mr. Tomasovic needs to do. So it's now 10:20. We'll come back on the record at 10:40, hopefully with those questions answered, and we'll be ready hopefully to sum it up and deliberate. And please, just as a reminder, do not leave the meeting, but definitely mute your microphone. Senator, you had something else before we take a break?
Do they need 20 minutes is the question.
Well, we're taking a regular break anyway, so we're just adding 5 minutes to it. That allows people to use the facilities if they need to. Mr. Balagopalan, yes?
Yeah, just a quick comment while they're deliberating on the issue is that I think we heard testimony, Ms. Frank, that the regeneration system's not working, I believe, because they have to have 48 hours or 4 days to get that working. So whether that makes a difference, whether on the emissions going to the flare, and whether they will need coverage during that period or during the variance, because potentially it could be higher or lower PM. We don't know. We don't have a baseline or reference, but maybe they have data from previous source tests.
I'm confused because I understood.
Well, no, I was saying is it does not appear the normal operation is with the regeneration system in operating, and flare 3 and 4 are used to burn the regeneration gas from the siloxane removal. But right now, I believe it's not in operation, so it's going or it's going to the flare without going through the regeneration system, because the engines are not running. They don't need to remove the siloxanes to do that.
Correct.
So they're just wondering if they have, if the source test company or the facility has baseline data, they can look at it to see if they need continued coverage for that PM emissions during the.
I just want to understand what you're saying, because my understanding of what the evidence has been in the testimony so far is that 3 and 4 are being used. Well, not 3. 4 is currently being used. 3 may be used under the variance for backup, which means just landfill gas. When the system is ready for them to use it for the regen, there's 4 days that are necessary before they even hook up the flare. So I don't know why they would need relief for the flares for that 4 days. Was that your understanding, or?
No, without a baseline source, I can't really say, but what I'm trying to say is without the regeneration system not in operation, the emission profile might be different at the flare versus when it's in operation. So.
Correct, and so we're trying to figure out whether that use of the flare needs to be incorporated in this variance or if it's covered in the other variance.
Yes, yes.
And that makes sense?
Yes.
Okay.
And I have just one question. I know we're kind of getting out of the formality of this, but I am curious if the if petitioner is willing to do a source test of those flares in their capacity as a backup flare. And if the preliminary results show that they're quote unquote clean, that they're operating within the parameters, once again, if we're willing to do that, how might those clean results in the backup capacity be used in this proceeding to provide protection or at least create a record that, hey, while operating in the backup capacity, you're not in violation. You know, we're establishing a set of evidence by doing that.
I think that's a question for maybe for Ms. Ediart, whether or not preliminary results are acceptable to the district as a show of non-violation or a show of compliance.
Were the preliminary results on this next round of testing?
The question was, I'm sorry, maybe you were focusing because you were not the witness at the moment. But the question, I think, is Mr. Alberian was asking that if the landfill undertakes to do a source test and get preliminary results using flares 3 and 4 or either one as a backup in their backup capacity, and preliminary results show that they are compliant. Would that be sufficient to the district for enforcement purposes?
I believe so. Yes.
Preliminary results. If that's the case, then that would you would no longer need variance relief to use the flares in that capacity. So I think the first question is whether the flares are covered under the other.
So I have an answer for that. It appears that the -5 case includes the flares, but it's not a variance from emission limits.
Okay.
So at the very least, on a short-term period, at the very least, but we would request to add the variance to flares 3 and 4 in their backup capacity.
Okay, and did you want to bring on a witness or talk about whether you want to do that source test for the backup? Do you want to take a break and figure that out?
Well, regardless, that source test can't happen immediately. It might be something we can talk about, maybe adding to a condition, but it's clearly not going to happen immediately. And we are here at this hearing today requesting variance coverage now because our interim variance has expired. So to that, from that perspective, I think we need to add it no matter what. Potentially the variance becomes irrelevant if we can show that it is clean in that capacity, but we do need coverage.
Okay, so you raised it, that's why I asked, but okay, let's take our break. And what I would suggest is that the parties speak with each other about the set of conditions and determine whether there are any changes aside from the two that were already discussed. Well, one being for number 5, that the insertion of the word normal. I think that we've already agreed on that. A discussion of condition number 8, whether it should be 14 days in that condition, and any other conditions that you may want to add or change. Can you have that discussion between Mr. Alberian and Mr. Tomsovic? Okay. So then now let's take a break let's come back at 10:45. Is that enough time? Okay. All right. So again, please don't leave the meeting. Just make sure you mute your microphone. We are off the record till 10:45. If you're, are you speaking to us, Dr. Bernstein? Oh, you were waving. I thought you were speaking to us. I was gonna say you're muted.
I'm just waving to everybody, all these smiling faces.
Oh, we're waiting. It is 10:45, so if you can hear me, come on back.
We're having some internet issues here,
Who is that? Oh,
Julie.
at the district, you are having internet issues?
Yeah, Faith office, I am. So you're good now. Okay,
Yes.
all right. Let me check Faith.
Okay, we'll wait.
My extension 2018, call that room.
Okay.
If you have problems.
Okay.
Great.
Really?
Yes.
Yeah, it's funny because your screen was like frozen, your little square.
Yeah,
Kinda
yours.
freezes. Yeah. Out here, so.
Okay, so you're good, Rosalinda?
I'm okay. Mm-hmm.
Okay, so then,
Paul is just checking on Faye's office right now to see.
okay, but as long as you're here,
Yes.
we can go back on the record. So we are back on the record, and let me ask Mr. Alberian or Mr. Tomasovic, are there any additional changes that we should go over or?
If I may first, did a quick kind of review, and I think we have been sidetracked a little bit. The reality is the permit at issue is a permit for both the operation in connection with the power plant as well as in its backup capacity. So what we have been talking about is a distinction. It's an operational distinction we're talking about, but not a permit distinction. So when we approached this hearing board for a variance, it was a variance from the permit conditions, and the permit authorizes both operational things. It just so happens that the failed source test happened during an operation in connection with the power plant, but that doesn't mean that the permit doesn't apply to its backup role. So I think that the distinction we are making is not a distinction that matters in the sense of this variance. We are asking for a short variance, and that variance applies to the permit, which authorizes two types of operation. So I can bring a witness that can talk about the fact that the permit does that, if that would be helpful, but I want to narrow us back where we are. I think we maybe are discussing something unnecessarily.
Okay, and Mr. Tomasovic, are you in agreement with that?
I agree it's a bit tangential. It's important to the question of what are the days of violations for which there could be excess emissions. But I have clarified with staff that on the basic information we've received that they failed this source test, and the formal source test reports have not been submitted from back in September. So we're just relying on what they submitted in terms of their representation that there are failed source test results. But that is what our enforcement staff would use to have emission factors to show whether or not the flares are in compliance. And it is looking at the permit conditions. Those are limits that need to be met whenever the flares are firing. So they do need, it makes sense that they would want variance coverage for whenever the flares are firing, because we could conceivably pursue enforcement on all those periods until they have successful source test results, which we hope they will soon.
Okay, well, thank you both for that. Were there any other changes to the conditions that you wish to present? No. And did the parties agree to that date of 14 days in condition 8 rather than 7?
We don't object to that change being made, and I'll attempt to put it in context in the closing statement if possible.
Okay.
And I believe our witness has said the 14 days would be acceptable. Is that correct, Ms. Frank?
Yes, that is acceptable if it is agreed that the district must have final source test report.
And we heard that from Ms. EDR.
Okay.
Okay, before I close the hearing then, and before I go to any public comment, if there is any, board members, are there any other questions or any other issues that you think need to be discussed in a factual basis before we move to deliberation? Okay, great. Well, thank you all for your testimony and also for the work that was done over the break. So I'm going to look and see, we have many participants and one attendee. I want to see if anybody wishes to be heard, any member of the public. And if you are a member of the public and you do wish to be heard in this matter, down at the bottom, there's a function to raise your hand electronically. You can do that. Or you can otherwise indicate to me by unmuting your microphone and speaking or showing me on your video. And I'm looking. Give you just a moment. Okay. I do not see any member of the public who wishes to be heard. And so I'm going to turn to Mr. Albarian for your closing.
Thank you. We are in a situation where we had a failed source test. We sought a variance, and through no fault of our own, a fire came through and created havoc. There's a huge amount of work that's being done on many facets trying to get the systems up and running, and information is coming in on a daily basis with changed circumstances. So we are scrambling to try to respond to that and provide this hearing board the most accurate and up-to-date information. But in the end, what we're looking at here is we sought an interim variance for permit conditions regarding emissions results for the flares 3 and 4. That permit authorizes operation in both its primary capacity in association with the power plant, as well as in its backup capacity to burn landfill gas when the power plant is gone or when the power plant is offline. And the circumstances that we proved back on October 7th still apply. We meet all of the 6 standards, and therefore we are respectfully requesting that this hearing board authorize our short variance request so we can continue to try to protect the public and deal with our regulatory requirements to destroy landfill gas. Thank you.
Thank you. Mr. Tomasovic, your closing.
Yes, thank you, Madam Chair and members of the board. Heading into the hearing, I think I had greater optimism about the facility's ability to really meet these proposed short variance conditions before the 90 days came up. I don't know that it's impossible for the facility to satisfy all these things. We hope they do. I do think it's appropriate for the board to confer relief to the extent that it can. And I do agree with opposing counsel that the fire did bring some havoc on the facility, and that includes complicating our picture of how this facility could get coverage. There is a separate variance proceedings for a regular variance to be had in December. And during the break, I actually called the clerk's office to see if the newspaper notice had already gone out for that. And it has. So whatever latitude the facility might have had to try to work in these same flare issues in that proceeding, might be a little bit constrained, and hopefully they can still work under an ambitious timescale to satisfy the conditions as revised for Exhibit B, and we won't have to rely on further proceedings or additional complications down the road. But with that, subject to the board's adoption of what we had for proposed conditions, and with the changes that have been noted, we would not object to the issuance of the short variance.
Thank you, board members. We were able to make these findings for the interim before the fire, when this short variance was originally set, just to make sure that the facility could be in compliance within the amount of time needed. And they definitely had already noticed this hearing. So no, it's not 100% certain that even if we decide today to grant a short variance, that they'll meet the final compliance within that time frame. We'll set a hearing for a regular variance, and we'll do that at the end. But as far as for the short variance is concerned, I think we can rely on the same factors that we relied on to make the 6 findings at the interim variance. And in particular, if we go back and we remember, since we've incorporated that evidence and testimony, back then we had heard that the failure on October 7th, no, the failure of that, I don't remember the date, but of that initial test, the source test was unexpected. There's a top to bottom cleaning of the flare that happens regularly, and the last maintenance had been done in September of this year, and it was unexpected. And also there have not been failures of the source test in recent years. And so for those reasons, we were able to find it was beyond their reasonable control. At the time we last heard this matter, the ongoing emissions were for a different reason. So we had excess emissions because even though that source test had been failed, the request had been to continue to run the regen system and to use the flares in their primary purpose, and to continue to do that until the flares could be further maintained, and that happened, and then source test redone. We now know that there was a fire, so now excess emissions are going to be different, of a different nature. It's going to be running of either flares 3 and 4, or one of those flares in conjunction with raw landfill gas. But as we've heard, either one are excess emissions, and either one requires variance relief under a short variance. So, but I can certainly make the finding with regard to the taking, again, any taking of this flare system, or non-use of this flare system, or non-running of this flare system, is a concern, because this is an essential public service. But on top of that, now we have a fire which caused the system not to work correctly for gas collection and destruction. So these flares are necessary to make sure that no nuisance is created and that landfill gas is burned off. So certainly I can make those findings, and that any excess emissions as a result of running those flares, I can make the finding that number 3, that the taking of those flares certainly outweigh any excess emissions. Excess emissions would continue to be monitored under the conditions of the proposed conditions, which are very similar to the conditions for the original, under the original variance. And as far as reducing excess emissions to the greatest extent feasible, they need to use the flares, they need to use the flare. But they did in terms of using it for its primary use, they already did the work that is necessary, hopefully, to make sure that it will meet that source test requirement, that will meet the PM emissions requirement for the next source test. And so we can probably take solace in the fact that they may not actually be in violation. They simply have not done a source test in order to confirm that. So while there may be excess emissions, they're likely to be very small, if not at all. So with that, I want to address the excess emissions fees after. But first, I just want to say that I can make all the 6 findings in that matter. Anyone else have any thoughts with regard to the 6 findings for the short variance? Mr. Balagopalan.
I agree with you. I think we can make the 6 finding. Whether they will meet the target deadline is somewhat questionable because of the quite a few moving parts, having the availability of the sources company to come and do the testing when they're ready to do it, and having the power plant in operation, normal operation, and then 48 hours prior to that is when they can schedule the tests after that, after the power plant is operating, and then 48 hours. So they may be, and because of all the damage to the landfill, which still, I think from what we heard from the other case, and they've made significant progress in doing the repairs and getting the landfill up and running, which is really commendable for the damage that they've sustained there. So it looks like they are on the right path to get the landfill back into compliance. If they don't meet the deadline, then they're left either, as you mentioned, maybe have to file for the regular variance. I don't know if they can piggyback on the variance that's coming next month. But they will have a better understanding as the month progresses whether they can meet the source testing deadline, and they can come back for a modification or a regular variance at that time, is appropriate.
Let me address that right now. Given the amount of time that needs to be given for that notice, they have to request it now, and I'm assuming they're requesting it now. Also, we have, both myself and the clerk have recalculated, gone back and counting October 7th, which was the first day that this variance relief took effect, that the interim variance relief took effect. It does end on January 4th by 90 days. So the first available time thereafter, the 4th is a Monday, and that should be fine. The 5th is a Tuesday. And Madam Clerk, is there anything on for the 5th? Because we can set that now. You're muted, but no, there's nothing already on.
No, there's not.
Okay, so then what we would have to do is now, we can't wait, because if they wait any longer, they won't be able to have a noticed hearing by January 5th. So we'll have to set that date as January 5th, and if they don't need it, they don't need it. But they can rest on they can use the petition they currently have and simply do what they've done for the short variance, which is file an amended petition as soon as you can do that, should you need additional relief. But we'll get to that once we all vote and we make a motion, but we would set it for January 5th. And that way, this would end January 4th if you need it that late, and then we pick up the very next day on January 5th. So there would be no gaps.
Yeah, I think with that clarification, I'm good at making the 6 findings also.
Thank you. Any other thoughts on the 6 findings? Senator?
Nothing on the 6 findings. However, there was a question asked to Ms. Franks regarding the optic cable, and there was no answer given. But to my understanding, engineering-wise, it's made of glass and be subsurface, be below the surface, not above, not at surface level. And if there were any damages to the fiber optic cable during the fire, it would occur at that time. I should have raised the question earlier on, but I can make the 6 finding.
Thank you. And I know that that's a question that still lingers, which is why we don't know yet whether they'll be in compliance with this by the end of the 90 days. But we'll see. Any
I
other
think Ms.
thoughts?
Frank did say that it was above ground. It's one cable, above ground, not underground. So
Okay. Ms. Verdugo-Peralta and then Dr. Bernstein.
Thank you, Madam Chair. I also had a bit of a concern with the target deadline, but I really do think that it's been commendable about all of the work that they have done after such a catastrophic event, and the fact that they have been so diligent and actually forthright about all this. I also can find the 6 findings and hope for a successful end to this. Thank you.
Thank you. Dr. Bernstein.
Thank you, Madam Chair. I also want to commend them for all the efforts that they've put into getting the situation rectified. Fire season has been ugly head repeatedly in California, and we've had several entities come before us with petitions due to that trash.
Your microphone is cutting out again. Sorry.
All right, I'll just keep it short. I can make the 6 findings. Thank you.
We definitely heard that though. But if you have anything else you want to say, you can make it just loud like that.
That's okay.
Okay.
I appreciate all the efforts that have gone in, by the way, obviously waste and recycling, to try to get this situation rectified as expeditiously as possible. Thank you.
Okay, if there are no other comments, I'm going to make the motion for the short variance, and then we'll take up the question of fees. Okay. In the matter of OC Waste and Recycling, Frank R. Bowerman Landfill, case number 5710-4, I move that we grant short variance, which would begin today. Sorry, which would begin today. Okay, sorry. Which would begin today and would go through final compliance with the short variance conditions, or until January 4th, 2021, whichever occurs first. It will be for the facility at 11002B Canyon Access Road in Irvine. It is for the flares 3 and 4 with their correct device and application permit numbers. And it will be from 203B 3002C1, conditions 32 and 36 of their Title V facility, their permit. Also, because we're not 100% sure, from 404A and also from Rule 409. We have incorporated, I move that we incorporate the proposed short variance conditions in Exhibit B and with the following changes. Condition number 5, the second to last line, after the word resuming, we insert the word normal before operation. So it's resuming normal operation. And condition 8, where it says 7 calendar days following the source test, we will insert 14 calendar days. And given that we haven't decided on the fees, it'll still be fine to leave that condition in there. Those are all the changes. Excess emissions are to be determined. Where are they? And they are, where are they estimated?
you want me to?
Do we have an estimation? Yes, thank you.
Yes, for flare number 3 is 22.03 pounds per day, and flare number 4 is 22.44 pounds per day.
Okay, now I see it. Thank you. So 44.47 pounds per day? Is that the
Yes.
total? Thank you. I see, Madam Clerk. I missed it on the minute order. And that completes my motion.
I'll second it.
Okay, Mr. Balagopalan seconds. Senator, you have a discussion on that motion.
Yes, on number 5. No, number 6. I think you included as an amendment, no later than January 4th, 21. At the end of that, resume.
I'm going to leave that out of my motion because it's taken care of, I think, in the term of the short variance. And I'm not 100% sure from the evidence that we heard that that will actually occur. So,
But as we were discussing the conditions, that was included, that's all. So the conditions were amended to include no later than.
Mr. Tomasovic, I think, had mentioned that at some point, but I think given that we're going to set the regular variance hearing, and I'm just looking at something from the clerk. Yeah, and if you could, and if that any amended petition, please be filed a week before. If you're still going to need a regular variance coverage on January 5th, if you can file at least a week in advance, any amended petition, please. But given that we're going to set that regular variance hearing, we're going to notice it. And this short variance can only go through January 4th, and it doesn't seem like we can guarantee that's going to happen. To put that into that condition would make it so that it's likely that they will fail to be in compliance with that condition. And I would prefer to leave it as part of the term. And then if they need regular variance relief, we'll take that up at that time on the 5th. Does that make sense, Senator?
By me.
Okay. Any other discussion on that motion? Okay, Senator, how do you vote?
Aye.
Dr. Bernstein, how do you vote?
Aye.
Ms. Verdugo-Peralta, how do you vote?
Aye.
Mr. Balagopalan, how do you vote?
Yes.
I vote yes. Motion passes 5-0. Okay, now we have the question of the fee waiver. So board members, going back to number 3, exhibit number 3, if we go to page 7, number 2 is a request for waiver of excess emission fees pursuant to hearing board's authority found in Rule 303G, waiver of all fees or other penalties pursuant to Rule 303P, since delays in retesting and other requirements are the direct and proximate result of the Silverado fire, which was declared to be a local emergency and by the County Board of Supervisors. I want to first start with 303P. I want to read what 303P says because I don't believe it does apply. Here's what it says. 303P, waiver of fees. All fees associated with this rule shall be waived for any petition for a variance filed as the direct and proximate result of any event declared to be a state of emergency, etc. I would say that under P, this does not fall under P. And the reason why is even though there are delays due to fire, this matter started as a result of a failed source test and an interim variance. The short variance was on calendar to make sure that final compliance could occur through a noticed hearing, etc. So the filing of this matter or the petition for variance was not filed as the direct and proximate result of an event declared to be a state of emergency. So all fees, including filing fees, et cetera, those were fees that were otherwise to be incurred because this matter already was on calendar, this matter was already necessary, et cetera. So I would say that would not apply in this situation. But let's go to G. Sorry, my computer is so slow. There we go. Oh, G, oops. Okay. Oh my gosh, so sorry. My computer moves it fast and moves it slow. Just give me 1 minute to get to G. Okay. G is adjustment of excess emission fees. And G says the hearing board may adjust the excess emission fee required by subdivisions D, E, and F of this rule at the request of petitioner or upon motion of the hearing board based on evidence regarding emissions presented at the time of the hearing. This is what I want to say about excess emissions. It's my feeling that excess emissions, given the evidence that we have received, excess emissions that are occurring, if they are indeed occurring, because again, the issue was hopefully fixed by petitioner when they undertook all of the maintenance that they did on the inside of the flares. So that was already done. There was no damage to the flares and the fire, so hopefully they are ready to pass that source test and there really aren't excess emissions. But regardless, right now during the pendency of this variance, for a large extent, flares 3 and 4, if they're operated, are going to be operated as backup for controlling landfill gas. Now we heard from Ms. Frank that in the past, these flares 3 and 4 are not generally ever used for that purpose. And so we can say that the reason why they are now being run as backup is because of the fire that devastated this landfill and the fact that the regen system is offline and there are difficulties controlling the landfill gas and the flares need to be brought in for that purpose. Given that, it seems to me that under G, I would be willing to support a motion that we would waive excess emission fees to the extent that the flares are being used in their backup capacity. Because again, it's the proximate result of this devastation of the equipment at the facility, at the site, and probably there are not likely to be very much, if any, excess emissions, given that the work has already been done. And that would be the motion that I would make and support. I'd like to hear other thoughts. Anyone have any thoughts? Senator.
Is that excess emission at the flares being measured by SIMS?
No.
No. It was a source test.
And it's a calculation that would, well.
How do you determine what the excess is?
We would actually determine the excess emissions based on that failed source test. And that's where we say 47, what was the number, sorry?
40, yeah.
44, 47, hold on, let me just get the right number. 44.47 pounds per day for each day that both flares are being used. And I would break it down even further. Mr. Balagopalan, I'm sorry, do you have still in front of you that breakdown?
Yes.
Because it's only flare 4 that is currently being used.
Flare 4 is 22.44 pounds.
22.44 pounds. And then what about?
Flare 3 is 22.03.
Okay, so for every day that flare 4 is being used as backup, it's calculated to be 22.44 pounds of PM. However, again, they were moving towards retesting, having done the work that they believe needed to be done. I think they were banging the insides of the flare, doing work that was above and beyond what they normally do for cleaning. Hopefully that was going to cure the deficiency. That's already been done. So it may very well be that there are no excess emissions, but they are calculated under the variance based on the last source test that they failed. So they would be incurring fees for 22.44 pounds per day for flare 4 if we don't waive those fees. And if they use flare 3 for backup, it would be 22.03. But my motion, if I make such a motion, would be only when they're used for backup. If they're being used for regen purposes and they're still under the variance, that's not a proximate result of the fire. So we would not excuse those.
Yeah, if I can add to that, I think we have to go under the assumption that they, even though they've cleaned in, potentially would have passed, but we have to assume that until they have the sources, we assume that they're still in violation. So I'm okay with using the date of the fire as when the breakpoint. I mean, we have to have a certain date, and then when we stop and waive the fee from the fire, because now they're using that as backup. So in October 27th.
Let me just stop you there because we're only talking under the short variance. So we're talking now forward. That's the request.
Right. Okay. So from this day forward, until they bring the regeneration system back into operation, at that time they will be running. Well, they won't be running 3 and 4 as backup. It'll be normal operation. No, I'm sorry. So until they do the test, so until then, it's potentially, we don't know until the test is done. So I think I'm okay waiving the fee until the test is done from today, or from moving forward from today.
And Madam Chair, I saw Mr. Alberian was tied up. I believe I'd heard him, or this is my recollection of the interim variance proceedings, was that issues regarding excess emissions fees were going to be deferred to this hearing. So it's conceivably in the board's purview to look back in time and make adjustments if they wish to. And I thought I heard something different just now, so.
Is that correct? No, no, you're thinking, it should have been due 15 days. Oh, after the notification. We didn't defer in this case. Didn't we defer in the other case?
Yeah, we did actually. You're right, Mr. Thomas.
Is it
I think in the
correct?
interim we did defer it until today.
Okay.
Discuss excess emission.
Okay.
And in abundance of caution, we have submitted excess emission fees, but a retroactive application would be something we would be open to and as needed. But the use of the flares in the backup capacity only started. The flares haven't been used for any capacity since the 26th. So really, we're talking about a very small amount of time here at this point.
My understanding was flare 4 has been used backup prior to that.
Just since Monday. So not a long period of time, just since a day and a half.
Okay. Okay, so we're talking about a very short period of time, and I think we can retroactively do that. Yes, Senator.
Are they calibrated as pounds per day? How did you come to that determination? In plus or minus?
That was based from the last hearing on the failed source test results. So the failed source test results led us to state excess emissions as the amounts that we just said. Does that answer?
And if I can clarify for the senator, they looked at the results of the test and what was allowed, and they subtracted the difference and multiplied by 24 hours a day and got the pounds per day.
They just calibrated it.
Based on the source test data.
So excess emissions are always what's allowed. No, what is being emitted minus what's allowed. And whatever's left over, that's the excess. So what they use for what is being emitted, they used the most recent source test that they failed. Then they subtracted out of that what they are allowed under the permit, and then the rest is excess.
Yes, gotcha. Thank you.
Any other thoughts on whether the rest of the board is supportive of this waiver of excess emission fees? And specifically, it would be for any use of flares 3 and 4 for backup purposes, as opposed for their primary use. Any other thoughts? Okay. All right, then I'm going to make that motion. Wait, if you just give me 1 second. Okay. Oh, we did take it out. Okay. Okay, sorry. So I am, in every way possible, it's being confirmed to me that we deferred excess emissions to today. And so we're going to include both under the interim. My motion will be to include both under the interim and.
I'm sorry, it was on -5 that we deferred.
Oh, was that, that's why, not this one.
Exactly.
That's what I thought. Okay. So this one, because I was looking at the minute order does include, and Mr. Alberian, you just said that you did actually pay excess emissions, correct? Oh, can you hear Mr. Alberian?
I'm sorry, I just didn't hear what you said just then.
You had just represented that you paid excess emission fees for this case already.
In an abundance of caution, yes. I was under the impression that we postponed it, but that the fees were paid in an abundance of caution.
The clerk just confirmed to me, which was what I thought, which is that we did defer, but in the other case, not in this.
Yeah, we may be there. The hearings are happening so quickly that they're easy to blend. So I don't have the facts in front of me to answer your question.
Okay. So then I'm just going to, since it's a very short period of time, I'm going to confine just to be clean and to make sure that there's no problem with the motion I'm making and I'm not going retroactive and shouldn't have. My motion is simply going to be, I'm going to move in the matter of OC Waste and Recycling Frank R. Bowerman Landfill, case number 5710-4, that we hereby waive excess emission fees for the days and only the days where flares 3 and or flare 4 are used in their backup capacity as a result of the fire to the landfill. Is there a second?
I'll second.
Mr. Dugal.
Chair, my only question and confirmation would be whether or not that motion would start on the 16th of November.
Well, it starts today, and the reason why is because my understanding is that there's only maybe been a day where it's been run. And since we didn't, it's not my belief that we did defer the discussion. I think retroactively, I don't think we can apply that. But since it's only a day, it shouldn't make that much of a difference. And I'm going to make it starting today during the pendency of this short variance. Ms. Verdugo Peralta, given that understanding, you still second the motion?
Yes.
Okay. Any discussion on that motion? Okay. Senator, how do you vote?
Aye.
Dr. Bernstein, how do you vote?
Aye.
Mr. Balagopalan, how do you vote?
Yes.
Ms. Verdugo Peralta, how do you vote?
Aye.
I vote yes. Motion passes 5-0. Well, lots going on, and we hope that we can get this and all other issues cleared up quickly. It sounds like, as I think Mr. Balagopalan pointed out, you're moving very quickly and rapidly, and that's great news, certainly for people who live around the landfill. So hopefully we won't see you on January 5th, but we are going to set regular variance hearing for January 5th, 2021. And I'll ask again, Mr. Alberian, if you have any amended petition for that hearing, please file that a week in advance so that we can have it in time for that hearing.
I will do so. Is there I mean, there will be probably some need to just provide an update at that time. So I guess I think I answered my own question. So thank you.
Hopefully it'll be a short hearing, much like this hearing, maybe even shorter, if we need it at all. Okay, any other business, board members, before we adjourn for today? Okay, thank you all for a nice, quick hearing, great testimony, and great deliberation.
Thank you.
Thank you.
We are adjourned. Thank you
Oh,
all.
Julie,
Yes.
I think we got an email regarding some additional documents for tomorrow's case today.
Okay, is that? All right, everyone, please check your email and make sure you have all the documents for tomorrow's hearing.
Busy week.
Yes. May get very busy end of December, beginning of January. So again, get prepared.
Yeah.
All right, thank you all. We are adjourned.
Thanks, everybody. See you tomorrow.
All right, bye.
Bye-bye.